Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today's topic is indirect transfer of shares, which is one of the most popular topics in the direct taxation jurisprudence. In case of indirect transfers, shares of a foreign company which has substantial Indian assets are sold on the basis of its deriving value from India. Now the seller entity is being made liable to pay tax in India. And we all have heard of this famous landmark, the Vodafone saga for a decade now, and the controversy had obviously begun from there. So, joining us today is someone whose name is synonymous in the field of direct and international tax advisory litigation. Today, we are joined by Ms. Vidushi Maheshwari, and at present, she is an associate partner at Economic Law Practices in Mumbai. And just to give you all a brief introduction about our amicus for today's session, uh, Ms. Maheshwari, she's engaged with Fortune 500 companies in relation to direct and international tax advisory and litigation. Decade-long experience includes structuring investment vehicle, entry and exit strategy, tax structuring assignments, pertinent establishment analysis, issues concerning double taxation, avoidance agreements, offshore fund taxation, AIF taxation, and she's also been a part of a number of high stakes matters before the honorable high courts, tribunals, etc. So thank you so much, ma'am, for taking out time for doing this complex issue for us. And it's a very challenging topic, and to take this up and to do it on a platform really means a lot. And anything that you wish to say before we start with our segment?
Thank you, Jay. Thank you. Thanks a lot for this opportunity. And I hope with this brief session, people are get at least the basics of the indirect transfers, because it's a little complicated, uh, matter of law. But I hope I'm able to convey the thoughts in an easy manner.
Absolutely. And the moment the name Vodafone crops up, then there are so many questions that are surrounding the same. So I'm sure that this presentation that you have, and I've also informed that you are having a PowerPoint presentation. So after a long time, we have a lucid presentation coming up. So can't wait for that. And I think the stage is set. The floor is all yours. Over to you.
Thank you. Let me just share my screen. Yeah. Thank you once again, Jay, for this opportunity. So today's topic of indirect transfer is the most interesting, debated, and controversial topic in the indirect tax laws. And and this basically began in 2007 with the issuance of a notice to Vodafone. But before I go through the life cycle of the entire controversy from where it began and what is the current state of it, let me first explain you all the basic concept of indirect transfers. So I've just taken this basic example. There is this holding company in the US, and there is this intermediary company in the Mauritius. Holding company holds 100% in the intermediary company, and the intermediary company is holding 100% in the Indian company. Now, if you see, the holding company is proposing to sell the shares of the intermediary company, and this intermediary company derives its entire value from the Indian company. So when the holding company sells the shares of the intermediary company, that is called an indirect transfer of shares, wherein the reason is because the value which is derived from the Indian company is getting transferred. Technically, one may think that this is a transfer which is arising in a foreign jurisdiction by a foreign company of a foreign company shares, and how can it be taxed in India? That's technically absolutely right. But however, considering the intermediary company whose shares are being sold will be deriving its value from the from the Indian company, the tax department may set out a claim to say that the holding company will be liable to tax in India. So this is the basic concept of indirect transfers, where the entire taxability is based on the valuation, is based on the how much value the intermediary company is deriving from the Indian assets, from the Indian company shares, and how much Indian value it is deriving. So now let us begin with the life cycle of this entire controversy, what had happened, how it had begun, and everything. So this controversy had begun way back in 2007, when Vodafone had acquired the shares through an indirect transfer way back in 2007, Various writ petitions were filed before high courts to challenge this particular show cause notice, which eventually went before the Supreme Court. And the Supreme Court held that the transaction is not liable to tax because they said there is no provision under the provisions of the Act. And this had led to the retrospective amendment of Section 9, wherein they said that now they incorporated a provision wherein they had got this particular kind of transaction within their ambit. Now, a very typical question which arises is that, okay, retrospective amendment is there, and the liability to tax the transaction arises under the Income Tax Act. But will that transaction also be liable under the double taxation avoidance agreements? As we all know, it's a bilateral agreement between two countries to avoid double taxation. So this was exactly the issue before the Honorable Andhra Pradesh High Court in the case of Sanofi, wherein the Honorable Andhra Pradesh High Court held that the transaction is not liable to tax in India pursuant to the DDAA. Now, they, as usual, the legislators had introduced the provision in 2012, but had forgotten to introduce certain, or rather explain certain terms which were critical to analyze the taxability. One of those terms was substantial. And in that sense, when this particular kind of a transaction came before the Honorable Delhi High Court in the Kopal ruling, they defined the word substantial as well. Now, all these transactions, whether it was Vodafone, whether it was Sanofi, or whether it was in Kopal, all these transactions had undertaken prior to 2012, that is prior to the introduction of the retrospective amendment. Now, what is the position which the courts are taking in relation to prospective transaction? In this situation, the courts have said that if if there is an indirect transfer, the transaction will fall within the ambit of the Income Tax Act. However, if there are beneficial provisions in the DDAA which enables the taxation to arise in the other jurisdiction, then that will prevail over the Income Tax Act. This exactly was the position which was held in the case of Sofina by the Mumbai ITAT recently. So the discussion now surrounds around 4 rulings, which will give you a gist of the entire controversy of indirect transfers. So let us now begin with the Vodafone ruling of the Supreme Court. I will not bore you with the facts, which are very detailed, but I will briefly take you through the facts, which is that there was this Vodafone International Holding Company based out in Netherlands, which was completely controlled by the UK company. This is the buyer in our transaction. And from a seller perspective, in 1998, the Hutchinson Group had incorporated CGP in Cayman Islands. Now, they have incorporated one entity. We have the buyer entity, we have the seller entity, which is the Hutchinson Group here. In 2007, the buyer entity had purchased the single share of CGP, which was the entire shareholding of this entity, from the seller entity, which was a Hong Kong based entity. Now, this CGP entity had, through various Mauritius and Indian companies, effectively held 67% in Vodafone SR Limited, which is now called Vodafone. Earlier, it used to be called Hutchinson SR Limited. So, this very simple facts. If you see in a gist, there's a Cayman Island company. There's a Hong Kong company which holds Cayman Island. Cayman Island holds Mauritius and Indian companies, and those companies eventually hold the income generating company in India. On these facts, when the transaction took place, when Vodafone acquired the shares of CGP from Hutchinson, at that time, the tax officer contended that this particular one share which has been transferred along with other rights and entitlements which was chargeable to tax in India. Accordingly, the IT department initiated the proceedings against Vodafone for not withholding tax under Section 95 of the Act here, because they considered Hutchinson to be liable to tax. Now, one may think that if the liability was to arise on Hutchinson, why the proceedings were initiated against Vodafone. So let me just briefly tell you about Section 195 as well. All of us know that there are various TDS provisions wherein the payer is obligated to withhold taxes. In this regard, again, Section 195 is there, which specifically says that if any payment is being made to a non-resident, and if that particular payment is liable to tax in India, in that case, the payer will be obligated to withhold taxes. Considering Hutchinson was a non-resident entity, the first obligation, so the Vodafone had an obligation to withhold taxes, and hence the Income Tax Department initiated the proceedings against Vodafone under Section 95 of the IT Act. Now, In 2012, the Supreme Court gave a landmark ruling and had pronounced various propositions which will have a far-reaching impact in indirect tax laws. So what did the Supreme Court say? The Supreme Court held that where the shares are transferred between two non-resident entities for a consideration paid outside India, India has no taxing jurisdiction, even if the underlying capital asset or value is related to a business conducted in India. Simple, two non-residents involved, the transaction is taking place outside India, the consideration is paid outside India, India has no taxing jurisdiction. The Supreme Court was very clear about that in this kind of a situation, there cannot be any taxation in India. They also said that the charging provision, which was Section 9 of the Income Tax Act 1961 here, is required to be strictly interpreted. There can be no purposive interpretation of a charging provision. Also, if the government intends to tax transaction of indirect transfers, it must be reflected clearly in the provisions in Section 9 of the Income Tax Act 1961 here. So let's have a comparison here of what amendments were done in 2012 and in 2019. So the Supreme Court also said that if the government intends to tax transactions of indirect transfers, it must be reflected clearly in the provisions in tax treaties, due to which a retrospective amendment was also introduced in Section 9. Now, Section 9 of the IT Act, when given a literal interpretation, does not permit a look-through or the taxation of indirect transfers. You can't tax based on the underlying assets. That is what the Supreme Court said. And they also held that the situs of the shares will be determined where the company whose shares are sold is incorporated and not on the basis where the underlying assets are situated. So the department contended that the shares of CGP are situated in India because it is deriving its value from India. But the Supreme Court denied this particular contention of the department and held that you cannot do that. Now, what had happened after Vodafone? In 2012, January, this ruling was pronounced, and when the budget of that year was announced in Feb, in that case, there were a lot of amendments which were done to the Income Tax Act. So let's have a comparison here of what amendments were done based on the key observations of the Supreme Court. The first observation, as we have discussed, indirect transfers cannot be taxed unless there exists a provision to tax it. Section 9 was amended to bring within its purview as an explanation that in similar kind of a situation, it is deemed to be situated in India and hence taxation can arise. They also amended the definitions of capital asset and transfer also. Now, Section 195, again, they said, Supreme Court said that it's only applicable to residents making payment to non-resident. Again, Section 195 was amended to provide that obligation to deduct tax under Section 195 applies to non-resident as well, irrespective of whether they have a place of business or presence in India. This is a very important amendment under Section 99, which was carried out by the legislators, because it not only impacts these kind of transaction, it implies every kind of a transaction where there are two non-residents involved and the buyer entity has nothing to do, the payer entity has nothing to do in India. Even then, it will have to withhold taxes and undergo various compliances in India relating to tax deducted at source. The last amendment which was done was relating to anti-avoidance rules. India did not have anti-avoidance rules, and it was primarily based on the judicial decisions, wherein the courts said that if the transaction has been undertaken to avoid taxes, in that case, there still be tax liable to be paid. And GAR was introduced pursuant to this kind of an observation in India in the Income Tax Act. So this was basically what had happened at that point in time in 2012 when the Supreme Court pronounced its decision and various amendments had undertaken. Now, next ruling which I wanted to discuss is the Sanofi ruling as pronounced by the Honorable Andhra Pradesh High Court, because this ruling was pronounced after the retrospective amendment was introduced, and this is relevant because more in light of the double taxation avoidance agreements. There is an amendment which has been done to the domestic tax, but will this domestic tax prevail over the double taxation avoidance agreement, which is a bilateral agreement between two independent jurisdictions? The facts, very simple. Let me not bore you with the names. There are two seller entities in France. There's one seller entity in France again, and there is a target entity again in France. All the four entities are in France, and the target company holds shares in an Indian company. In 2009, both the seller entity, the French seller entity, had sold the shares of the target French entity to a French buyer entity. When this transaction took place, the tax officer again said that the buyer entity, which is Sanofi in this case, is an SSE in default for not deducting tax at source under Section 195 while making payments to the seller entities. So both the seller entities at that point in time had approached the authority for advance ruling to determine the tax liability of this particular transaction, which was given a negative ruling wherein the AR said that the transaction was not liable to tax in India, and all the three parties, the two seller entities and the buyer entity, approached the Honorable Andhra Pradesh High Court by way of writ petition. Now, what did the Andhra Pradesh High Court said? The Andhra Pradesh High Court said that, so before I go into the details, one particular question which was raised before the Andhra Pradesh High Court, which was the contention of the tax department, was they questioned the commercial substance of the target entity. They said this is a conduit entity. So that was the first proposition which was laid down on facts and on basis of the circumstances, everything. After analyzing detailedly, the Andhra Pradesh High Court said that the target entity is an independent corporate entity registered and is a resident of France and has commercial substance. And it also has been holding shares of the Indian company since its inception. And hence they said that there is no warrant for us to lift the corporate wheel in the present circumstances. Accordingly, they said that the entire transaction, the structure which has been put in place, has nothing to do and they was not intended to avoid taxes in India. And accordingly, they said that the transaction, this particular transaction, is chargeable to tax in France in terms of the provisions of Article 14(6) of the DTAA, which gives right to the resident jurisdiction of the seller entities. Now, again, they said because there was a retrospective amendment. As I told you, this decision was pronounced when the retrospective amendment was already in place. So at that point in time, they said a unilateral decision which was undertaken to the domestic tax laws of India cannot as such have an impact on the DTAA. Hence, DTAA will prevail, and accordingly, they said the taxation is not liable to tax in India. So if you see both these transactions, one ruling said that the transaction itself is not liable to tax, which led to the retrospective amendment. Even after the retrospective amendment, this particular ruling of Andhra Pradesh High Court said that even if it is liable under the Income Tax Act pursuant to the retrospective amendment, even then under the DTAA it cannot be. DTAA will prevail over the domestic taxation. Now, as indicated earlier, there were few terms which the legislator had not interpreted, had not defined under Section 9, which the one of the main term was substantial, which is basically the threshold based on which you can say that the target entity, the intermediary entity in our example, derives value from the Indian company or the asset situated in India. In this case, this particular transaction came up before the Honorable Delhi High Court in the Kopal ruling case, wherein they had said, again, the tax department had questioned the commercial substance of the transaction. What is the commercial rationale of it? Again, the Delhi High Court said that if the transaction would have been structured as contemplated by the revenue, the commercials would not have been achieved. It was concluded that the sale of shares at the Mauritius level, because the Mauritius company here was sold, this was the target or the intermediary company, cannot be stated to be without any commercial reason, but only to avoid tax. Again, they said that even if the transaction is structured in such a manner by as suggested by the revenue, even then the company which has been sold is not deriving that much value from the share from the Indian assets. At this juncture, they concluded that it was concluded that gains arising from the sale of shares of a company incorporated overseas, which derives less than 50% of its value from assets situated in India, would not be taxable under Section 9 of the Act, read with explanation 5 therewith. Thus, the Delhi High Court went on and defined the term substantial, which is the critical aspect to determine whether a particular foreign company whose shares are being sold is liable to tax or not. And they have said it is 50% value. So when a target company, when a foreign target company is being sold, and if it doesn't derive value from India, which is more than 50%, then that particular transaction will not be liable to tax in India. In a situation like a Mauritius target company is being sold, and a Mauritius company holds Indian assets, it holds other Asian country assets as well. In that case, an evaluation will be undertaken, wherein it will be determined whether the Mauritius company is deriving what value from each jurisdiction. And if the Indian value is determined to be less than 50%, in that case, they will the conclusion which we will arrive will be not liable to tax in India. This led also, after this, in 2015, various terms were defined, and again substantial was defined at 50% value. Lastly, if we have noticed that all these rulings, which was Vodafone or Sanofi or Copal, were all in relation to the transactions which had already undertaken prior to 2012. So these were all retrospective transactions. Now, what positions the courts are taking in case of prospective transaction? For that, let us refer to the Mumbai ITAT recent ruling in the case of Sofina. Now, again, the facts. Sofina is a tax resident of Belgium. It held certain stake in a Singapore-based company, which in turn held 99.99% in an Indian company. Now, Sofina sold its entire stake in the Singapore company to another Indian company, which deducted taxes. And accordingly, Sofina, while filing his return of income, claimed that I am not liable to tax pursuant to Article 13.6 of the DTAA between India and Belgium, and accordingly, and put up a claim before the income tax authorities. The tax officer invoked the indirect transfer provisions under the IT Act and said that the sale of shares of the Singapore company is liable to tax in India. The aforesaid view was also upheld by the dispute resolution panel, and accordingly, Sofina came before the tribunal, Mumbai tribunal. Now, what was the exact issue before the Mumbai tribunal? The issue was whether transfer of shares is taxable in India as per Article 13.5 of the India-Belgium DTAA, read with explanation 5 to section 9, or is it regulated by Article 13.6 of the DTAA and taxable in Belgium? Now, the Mumbai ITAT, based on facts and circumstances, held that the shares which have been transferred by the SSE in the present case are of a Singapore-based company. Therefore, in the absence of satisfaction of the precondition that the shares transferred should form part of the capital stock of a company which is a resident of a contracting state, the application of Article 13.5 stands excluded. So what is Article 13.5? One of the conditions of Article 13.5 of the India-Belgium DTAA says that the transfer of shares should be of a company which is a resident of either of the contracting states. So here, either of the contracting states in our situation is India or Belgium. What had happened exactly in the facts? The SSE here, the Belgian company, had transferred the shares of the Singapore company. So this basic prima facie condition was not getting satisfied. The 13.5, which is not applicable, it stands excluded because the condition is not satisfied. They also said that the retrospective amendment which was done to section 9, wherein explanation 5 was introduced, does allow a see-through approach, but similar kind of a see-through approach is not permissible under Article 13.5. It does not say that the taxation will happen based on the valuation of the assets which are situated in India. It has nothing to do. It's a prima facie provision wherein if you meet both the conditions, then it is liable to tax, otherwise not. They also held that explanation 5 to section 9(1) of the IT Act does not define residence of a person and only deem shares of a foreign company to be located in India. One of the arguments of the tax officer was also that the Singapore-based company, since it is deriving its entire value from the Indian company, it also become a resident in India. This argument was also denied because they said that this only deems the shares to be situated in India and has nothing to do with the residence of a company. In fact, as a matter of fact, all of us know that there are specific rules and regulations pertaining to residence under the IT Act when it comes to a company as well. Again, Following the Sanofi judgment, in this case also, Mumbai ITAT held that the unilateral amendment to a domestic law cannot be allowed to override the provisions of the DTAA. Merely because there is an amendment which has been carried to Section 9 would not mean that the DTAA is also amended. DTAA should also be amendment. And that process, as we know, it's a bilateral agreement between two countries. Both the countries should say yes or no to a particular amendment. Only then, and then there is a process which has been set out which needs to be followed. Merely because you have amended a domestic law would not mean that you can tax that kind of a transaction. Again, in conclusion, the tribunal held that since Article 13.5 of the India-Belgium DTAA is not applicable, gains would be taxable under Article 13.6 of the India-Belgium DTAA, which gives the right of taxation to Belgium in this case. Article 13.6, similar to what was there in Sanofi, Article 14.6 in the France Treaty, it says that the taxation will arise in the jurisdiction of the residence of the alienator, and likewise, in this case also, the SSE was liable to tax in Belgium and not in India. And accordingly, the court said that 13.6 is applicable and not 13.5. So now I have taken you through all the different stages of this controversy. When there was no provision, when the provision was there, when what is the applicability of DTAA, and what is the applicability of what various terms which have been defined, and what is the position regarding the prospective transaction. So this is what I wanted to take today, and that's it from me. And thank you so much. I hope this gives you at least a gist of the indirect transfer controversy which is presently there in India. Thank you.
Very well there. So thank you so much, Ms. Maheshwari. Dealing with such a complex issue and then doing it with so much of ease and effortless. I mean, what a phenomenal presentation that was. And it's not easy to take up such a challenging issue that has so many questions surrounding the same. And the objective of our channel to our viewers who are watching has and will always be to solve legal issues and to do it in the simplest of the ways so that it's easier for everyone to understand and comprehend. I think this episode perfectly achieves that objective. It fulfills the objective and it has completely lived up to our expectations. So thank you so much. I'm sure this will immensely benefit all our viewers who are watching, and I'm sure this must have solved most of the queries, that we received as and when we posted this topic were in advance. So anything that you wish to say before we wrap this up?
Again, thank you, Jay, for this opportunity, and it was lovely to be here and give this presentation, and looking forward for more this kind of presentations with you. Thank you.
Absolutely. So thank you so much, everybody. And our email is mentioned on the channel in case if you still have any queries with respect to any fundamentals, concepts, or vis-a-vis the content that you saw, feel free to write to us. We'll be more than happy to forward the same to our amicus for today's session. Thank you so much, Ms. Maheshwari, once again. It's goodbye for now.
Thank you.